Good evening, everybody, and a very, very warm welcome to the University of Hertfordshire. My name's Quinn McAlister, and I'm the Vice-Chancellor, and it's a real pleasure for me to introduce this lecture this evening. Before introducing our speaker, though, I have two things to say. The first is just in case you haven't read your card, this lecture is given in the memory of Sir Christopher Staughton, who was a distinguished judge who was first called to the bar by the Inner Temple in 1957. And at each stage of Christopher's career, he had to disentangle extremely complex commercial disputes, and it was a consequence of doing that he rose through his profession. He applied his knowledge and command of the law with rigor and logic, for which he became renowned. And so this is a lecture in his memory, and we have Joanna here, Lady Staughton here in the audience. Also this evening, for your information, Grace, our speaker, is joined by some of the West Midlands Crown Prosecution Service colleagues. They're in the audience for her lecture today, but tomorrow on Friday, she and her colleagues are going to support a student competition in the Hertfordshire Law School with our criminal justice students. And the winning student will win a week's internship at the West Midlands CPS. So that's terrific. Now, let me turn to the main act. It's a real pleasure for me to welcome Dr Grace Ononiwu OBE to give this year's Sir Christopher Staughton Lecture. Following a BA Hons in Social Sciences and a law degree at the University of Hertfordshire, at the time still the Hatfield Polytechnic, and graduating in 1988, Grace qualified as a solicitor in 1991 and took up a role with a private firm of solicitors in High Wycombe, practicing criminal law. Working as a defence solicitor, her firm advised that she spend 2 years training with the Crown Prosecution Service, which she began in 1991. And following this, Grace held a number of roles in the CPS before being appointed Chief Crown Prosecutor for Northamptonshire in April 2005. This appointment made her the first Afro-Caribbean female solicitor to be appointed to that position in the history of the CPS. Indeed, Grace has made a significant contribution to the CPS equality and diversity agenda, previously acting as chair of the National Black Crown Prosecution Association. She's recognised now as one of the most senior women in the CPS and has been on the power list for the last 3 years. In April 2009, Grace was appointed Legal Director for North Region CPS London before becoming Deputy Chief Crown Prosecutor for all of the London districts. Grace then took on the role of Chief Crown Prosecutor for the East of England between 2012 and 2014, before being appointed as Chief Crown Prosecutor for the West Midlands in June 2014, and that's her current role. She's responsible for all criminal prosecutions investigated by the police in the West Midlands CPS area, which incorporates the West Midlands, Staffordshire, Warwickshire, and West Mercia. This university was delighted to award her a Doctor of Laws in 2017. Grace, could I now invite you to give your lecture, the title of which is The Ideals of Public Service, What Everyone Should Know.
Thank you, Quinton. Thank you very much. Can everyone hear me at the back? Good evening. May I first say how very honoured I am to have been invited to deliver this year's Sir Christopher Staughton Memorial Law Lecture. The title of the lecture today, The Ideals of Public Service, What Everyone Should Know, the Crown Prosecution Service in Contemporary Britain, and I will try very hard not to get fired today. I chose that title because a lot of the feedback that we get is that people don't really know what we do, even though we've been around for quite some time. So I'm hoping to explore that a bit more with you today. Sir Christopher devoted his working life to the law. First called to the bar by the Inner Temple in 1957. He became Queen's Counsel in 1970 and thereafter fulfilled a series of judicial appointments which saw him sit both as Lord Justice of Appeal and later as President of the Court of Appeal of Gibraltar. As a Hertfordshire resident, Sir Christopher was a staunch supporter of this university. He was awarded an honorary degree in 1996, and I know how very proud this university is of its affiliation with him and his family. He particularly supported this law school, and since 2010, generously supported, and his wife, Lady Joanna Staughton, who I'm pleased is here today, continues to support an endowed scholarship for students on the LLB law degree. Lady Staughton herself has significant ties to the university, having served as both university governor and member and chair of the university's development committee. It is, of course, impossible to adequately summarize the legal career such as Sir Christopher's. But if I may, I would like to highlight one aspect of his work, away from the highly complex commercial cases in which he specialized. And it's the work as patron of Clarity, a body which advocates the use of clear legal language, which, as Sir Christopher clearly recognized, and I agree, is so important in any modern legal system. I know the university is incredibly honored that Lady Staughton has allowed this annual lecture to be named after Sir Christopher. And I'm delighted to have an opportunity to, and I hope I do it credit, to do this in his name. Now, as an alumnus of this university, I'm always pleased to return. I studied here when it was Hatfield Polytechnic, and I graduated in the class of 1988. Now, I know all of you are probably thinking that I don't look old enough. And you would be right. I studied law and the social sciences, a relatively new course at the time. And following graduation, I attended the Guildford College of Law, where I completed the professional exams to become a solicitor. My articles, which I suppose it's the legal trainee scheme as it's known today, were in private practice, an 8-partner firm in High Wycombe. It was always the plan to remain in private practice and do criminal defense work. I first decided I wanted to be a lawyer when I was about 8 years old. My father was stopped for speeding. He was speeding, by the way. I said, "Daddy, don't worry. When I grow up, I will be your lawyer." To be honest, I didn't really know what that lawyer thing was. My mum didn't go to school. She couldn't read or write. In Nigeria, where she grew up, she was one of 6 children, and she was the child that was selected to help my grandmother support and look after the family. So she couldn't help me with that homework, but she instilled in me the enthusiasm to succeed. I had no professional role models, didn't know any lawyers, so I looked for examples elsewhere. I used to watch a program called Crown Court at lunchtimes. I was enamored by the wigs and the gowns. It was always the plan to do defense work. To be honest, there could be no other plan, because where I grew up, it was not the done thing for people of colour to prosecute or to join a police force. As controversial as that might seem today, it was seen as though you were working for the enemy. Turncoat, coconut, or other similar terms were used to describe those who ventured in that territory. That was why, when one of the senior partners, who I respected very much, at the firm at which I was working, advised that I should consider doing prosecution work, I was conflicted. Grace, he said, one day you're going to be a very important lady. If I had it all to do again, I'd learn how to prosecute. It will make you a more rounded lawyer. Why don't you join the CPS for 2 years and then come back? Well, of course, I never did. In that time, I learned many things. But the most obvious was that victims of crime come in all colours, all who need our help and deserve the protection of the law. Making a contribution in keeping the public safe, protecting the rights of victims of crime, gave me a strong sense of purpose. I've now been in the CPS for 28 years and a chief officer for 14 of those years. Even today, even at the most challenging of times, my commitment to public service has not wavered. So who exactly are we? Who are the Crown Prosecution Service, the CPS, and what do we do? Well, we were created in 1986 and currently employing about 3,000 lawyers. The CPS is the largest employer of criminal lawyers in England and Wales. Simply put, our job is to ensure the right person is prosecuted for the right offence and that trials are fair so that offenders are brought to justice wherever possible. We are split into 14 regional divisions, of which my own, the West Midlands, is now the largest, and I would say the best. All of these regions are headed by a Chief Crown Prosecutor, and these 14 divisions serve the 43 police forces across England and Wales. My region covers 5 police forces: West Midlands, which is the second largest force in the country, Staffordshire, Warwickshire, West Mercia, and we also cover the National British Transport Police. We have a number of specialist casework divisions, each led by the equivalent of a Chief Crown Prosecutor. And at our helm is the Director of Public Prosecutions, currently Mr. Max Hill, QC, another Hertfordshire man who gave last year's memorial lecture just a few months before taking up that position. Now, although we are completely independent of political influence, we are nonetheless accountable to Parliament and accountable to the public. And as such, we are superintended by the government's chief legal advisor, the Attorney General, Mr. Geoffrey Cox, QC. In all, the CPS employs approximately 6,000 dedicated people, lawyers, paralegals, and administrators. And together, we are at the heart of the criminal justice system in England and Wales, working together with our criminal justice partners, such as the police and the courts. We work together to protect the public and help create a safe society. Now, while we have these close associations with the other criminal justice agencies, we are completely independent from them. And in that way, the integrity of the system is preserved. Our work is demand-led. We do not investigate crime or choose what cases to consider. The CPS must review every case referred to us by the police or other investigators. Sometimes, our job is to provide expert legal advice in the very embryonic stages of a complex investigation to help build a strong case. Sometimes cases come to us at the end of a police investigation, at a point where, in certain cases, the police must obtain our permission to charge a suspect. Or in other cases, it comes to us after the police have already charged someone. No matter the circumstance, we are the gateway to the criminal justice system, and our job is to make key decisions on whether or not the case is put before the court. It is a considerable responsibility, not least because we must never forget that every case involves people, victims and witnesses and their families, suspects, defendants and their families. Our decisions have enormous ramifications on the liberty, livelihood, reputation, and safety of an individual. And our lawyers work hard not to lose sight of that. I guess that's what bothers me. It bothers me a great deal when sometimes we are portrayed organizationally as uncaring. In my experience, there is nothing further from the truth. Our lawyers know that whilst the case they are currently deciding on will be one of many cases for them that day, to the people at the heart of it, whose lives have actually been affected by what they are reading about, that case often represents the worst thing that's ever happened to that victim, or the worst thing that that witness may have seen, or even the worst thing a suspect or a defendant may have done. We are conscious that the nature of our work is such that the people, public, have to engage with us, but not out of choice. We approach our casework robustly and sensitively, and at all times, maintaining that crucial independence and objectivity. Because it's not for us to decide whether a person is guilty or what the sentence should be. That's for the courts. It's our job to fairly assess the evidence wherever it may lead us. Because as important as it is to bring offenders to justice, it's equally important that the innocent are not convicted and that weak cases are not brought into the system or not stopped at an early stage, thereby avoiding the inevitable anxiety and distress that a criminal case brings to all involved. So, how do we make our decisions? Our role is not an easy one. It's not easy because we know we cannot please everyone at the same time. Our decisions are regularly scrutinized, sometimes in the full glare of the public. In 1986, when the CPS was set up, no one would have ever thought that our activities would be as public as they are today. We recognize that this is our new normal, and our focus has to be to do the right thing, knowing, of course, that the right thing is not always the easiest thing to do. In considering a case, all prosecutors must apply the Code for Crown Prosecutors, affectionately referred to by some of us as the Prosecutor's Bible. The Code applies to all cases. It's our key decision-making tool, and it sets out two tests. The first stage is the consideration of evidence. If the case does not pass the evidential stage, it must not go ahead, no matter how important or serious the case may be. If it does pass the evidential test, prosecutors must then go on to consider the second stage and decide if a prosecution is needed in the public interest. These decisions can be very difficult, and ones in which two perfectly responsible and professional lawyers may disagree. But the decisions must be made in this way. All over England and Wales must be. Last year, we brought more than 500,000 prosecutions with a successful outcome in 4 out of 5 cases. The cases we handle are extremely diverse, from the contested speeding case in the magistrate's court to the more serious, imaginable offences such as homicide and terrorism. But no matter what the case, our code and the tests that we apply is the same. But it's not just about the mechanics of how we make the decision to prosecute in accordance with the code that matters. It's also how we go about making that decision, because we are more than our code. We have core values which are important to us, and so important that they appear on the homepage of every staff member's computer screen when they log on each morning. And these values state: we will treat everyone with respect. We will be independent and fair. We will be honest and open. We will behave professionally and strive for excellence. Our staff are expected to uphold these core values and apply them to all aspects of our business. What we do and how we do it matters. I would say over time that we've become a more transparent and reflective organisation. On occasions where things go wrong, as they sometimes do, we work extremely hard, where possible, to put them right. For us, it's important that the right decision is made, and I guess it's a reflection of a more modern and mature organisation that we today have the Victims' Right to Review scheme. In 1986, if we made a decision not to proceed with the case, that would be the end of it as far as the victim, for the victim as far as we were concerned. Of course, they could complain, but that would be as far as it would go. That's not the position today. Today, a victim has the right to challenge our decisions, and rightly so. Those cases are looked at again by prosecutors who have no previous dealings with it. And on occasion, the original decision made by the earlier prosecutor is overturned. All of this we do under the public lens, which is as should be. But as I said earlier, it's not always easy to manage the public's perception of us, because we do get it right most of the time. But I say when we don't, the modern CPS is open, honest, and transparent. If we get it wrong, we must say so. If we can put it right, then we must. But if we can't, we need to be honest about that too, and apologize if appropriate. Now, there are many cases that I've handled over the years that resonate with me. But there's one such case that I will never forget. A young lady reported to police that she had been assaulted by her partner. The injuries sustained by her were consistent with a common assault. The police referred this matter to us for consideration. The lawyer who reviewed the case concluded that there was insufficient evidence to proceed and advised no further action. A few weeks later, this young lady was found dead in the street. She had been brutally attacked by her partner. She was 8.5 months pregnant. We prosecuted her partner for murder and destruction of a child. But during the trial, questions were asked as to why we had not prosecuted the earlier assault. These questions of us moved from the courtroom into the public arena and gained momentum with the media. Now, as the Chief Crown Prosecutor, I'm accountable for every decision made in my office, regardless of who may have made it. I considered the case personally and concluded that the decision not to prosecute the earlier assault was wrong. I met with the family. It was one of the most difficult meetings that I've had, and I have many meetings with families. It was the most difficult meeting because I knew I couldn't make it right. To their surprise, I wasn't defensive. They expected I would be. Isn't that what major organizations do? I didn't in any way try to justify the decision my lawyer had made. I was honest with them. the decision was wrong, and I had to respect the impact this wrong decision would have had on them. I apologized personally and publicly for this wrong decision. Now, I knew that there was no guarantee that even if the right decision had been made, that it would have avoided the tragic situation that led to the death of this young lady and her unborn child. The defendant would have been charged with common assault, and in my experience would have been granted bail. I also knew that the person responsible for the death of this young lady and her unborn child was the defendant. But from my perspective, that wasn't the point. The point was that the public expectation of us today is greater than ever. We are expected to make the right decisions at all times, and on this occasion, we did not. A constant reminder that stays with me of the consequences of what we do and how important it is to get it right. So let's talk about our people and recruitment. I'd like to dispel a myth today. We do not sit in ivory towers. We do not shut ourselves away from the rest of the world. We are real people, and we get out quite a lot these days. Building key relationships with anyone or any group that can help us continuously improve what we do. Now, there was a time when the CPS was seen as a somewhat poor relation to our private practice colleagues, but with the development of our service, those days are long gone. We simply cannot accommodate all the people that want to come and work for us. Let me tell you about that. We have people from the bar that want to join us, people from the court service, people that worked in private practice, doing defense work. So it's really encouraging to see that level of interest. In terms of our recruitment, there are now many potential routes to the CPS. We offer varying types of apprenticeships. We have highly successful legal trainee scheme, which is open to anyone wanting to qualify as a solicitor or barrister. We want to attract and retain the best prosecutors we can. But being a great prosecutor is not necessarily the same thing as being a great lawyer. It takes all sorts of people to make up the truly inclusionary workforce that is the CPS today. We are proactive in finding the right people to join us. For those reasons, the minimum degree grade requirement for the legal trainee scheme has been deliberately set by us at 2.2, instead of the industry standard of 2.1. Now, it's not because we have lower standards, far from it. In this way, we can ensure that we don't prematurely sift out capable and suitable future prosecutors. Whilst a basic grasp of legal knowledge is, of course, a prerequisite and is tested in our recruitment process, the process is also designed to be highly practical, enabling us to capture those instinctive prosecutors, those who on paper may not be the best candidates, but who have the personal skills, attitude, and passion, which is truly great and truly what we expect to see in great prosecutors. These people might have been lost to us. Last year, we had 1,700 applicants for an eventual 38 places. But I'm proud to work for an organisation that can now pick and choose from the very best. And it has its own definition of what best looks like. Away from apprenticeships and the legal trainee scheme, we have a number of other strategies to help us attract and recruit the best people we can. One of our most successful is our work experience strategy, where we place university students on placements in CPS offices. These students have the opportunity to shadow most areas of our business, including prosecutors at court, prosecutors making charging decisions, and maybe even the Chief Crown Prosecutor. Extending to the more experienced, we understand that many qualified solicitors, especially those in criminal defence work, may be actively considering a change of career, but it may be a very daunting step. This is a feeling I shared all those years ago. To that end, we offer fixed secondments, an opportunity to try it before committing. It may seem as though we're giving the fox the key to the henhouse, but we've got nothing to hide. Defence lawyers often make excellent prosecutors, and if they make the grade, we will want to take them. So what do our people look like? Very different to what they looked like in 1986. Our people come from all backgrounds and with hugely varied life experiences. When we say that equality and diversity is important to us, we really do mean it. We're good at recognizing that people don't necessarily fit in pigeonholes, that there's not just one way to be effective, and not one size fits all. So it's no accident that we have the Investors in People Silver Award placing us in the top 14% of organisations for its approach to managing and developing its workforce. Nor is it a surprise that we were listed in 2018 as the top 10 BAME inclusive employer by a leading career site dedicating to showcasing employers that create an inclusive work environment. We're in the top 10 of working families, and we are recognized as a disability-confident leader. Now, I started by saying that it's important that we never forget at the heart of what we do is our people, both within our service and within the communities that we serve. And for us, equality and diversity and community engagement aren't just trendy tick box exercises. They are at the core of our business because it's essential that we, as far as possible, understand and are reflective of the society that we serve. The general population is extremely diverse and continues to diversify. It's made up of people of all backgrounds, nationalities, ages, colours, physical ability, educational levels, and family units. That society is changing. The population is aging, and we know that older victims, witnesses, and defendants face particular issues in the criminal justice system. We know that older people may be more vulnerable to particular crimes and may need a different kind of support through the criminal justice process. We see more crimes involving children, both as victims and defendants. They too have particular needs. We also know that some crimes have a disproportionate impact on particular groups and communities. Hate crimes, such as those motivated by hostility towards a race, religion, sexual identity, disability. Instances of domestic violence. Sadly, we know that these types of crimes are on the increase. And it's important that we truly understand the effects of those crimes. To that end, we develop ways of educating ourselves. We have a strong volunteering culture in the CPS, where staff go out into the communities, volunteering their time, getting to understand more about the communities we aim to serve. We open our doors with our local scrutiny and involvement panels, such as our hate crime scrutiny panels, where panel members, amongst other things, scrutinize a selection of concluded cases, including some of the letters that we write to victims. As an essential element of these panels, relevant community members are represented. They advise us, they assist us, some of the nuances that involve particular communities. They give us feedback on our handling, and it helps inform the way we work and how we approach these cases. It is such a valuable source of information, and we learn, as I say, an enormous amount from that work. In one panel last year, we hosted the Gypsy, Roma, and Traveller community. We know that children from that community are substantially overrepresented in youth custody. From a minority group who, in the last census, declared at around 0.1% of our population, its children nevertheless make up 12% of all children in secure training centres. So we know it's an issue. But it's engagement like this that drives us forward and leads us to devise strategies and engage sections of society who may not have had the best of experiences with the criminal justice agencies in particular. So not only do we work hard to ensure our workforce is reflective of wider society, we work directly with that wider society to ensure our workforce understands the impact of offending on all sections of communities. But it's not just our society that's changing. Crime is changing. Certain crimes are becoming more complex. Cybercrime, international crime, becoming increasingly complex, and may be more so with Brexit. We don't know. Modern day slavery comes to mind. We know we have to be proactive and not just sit back and wait for new crimes to be invented. We have to develop strategies to cope with obvious future risks. Crime and criminals change, and we have to adapt and modernize to do our part. Technological advances have made a huge difference to the way in which we work. We are in this digital age, and it causes real challenges for us as a criminal justice system. When we look at disclosure, and there has been a lot of publicity over that over the last year or so, a lot of the focus was placed on the police and the CPS, but the reality is a challenge for the entire system. laptops, computers, iPads, mobile phones, Snapchat, Instagram, Facebook, I can keep going. There may be relevant information that should be disclosed to the defense or form part of the prosecution case. But sifting through thousands and thousands of information, pieces of information, in what might be just a relatively simple case is a real challenge for the system. We say we need to be transparent in our handling of this. Because if we're honest, the sheer volume of the material just comes from a mobile phone. Never mind anything else. We may be in a position where no one sees everything. This is why we have to be very open about what we have, what we've seen, what we plan to see, and what we don't plan to look at. And we need to have that conversation very early on to enable the courts to properly case manage with us. No longer are prosecutors carting lots of files around. They have laptops now. Even in the courts, it's digitalized. We have a 24-hour service giving advice, making charging decisions, no matter what the hour. Our staff work very differently now. They can work from remote locations. So, for example, in the West Midlands, I am heavily recruiting, but I can't get the numbers I want in the West Midlands necessarily. So I'm having to set up remote teams around the country. So I'll have a team in Liverpool. I'll have another team in the Northeast. I think I might have a team in Wales. It increases the capacity of the CPS, and because we are digital now, we can do so much more. Now, I didn't know when I left this institution in 1988 where I would end up, but I found my legal home, and it's been my privilege to work for the CPS for the last 28 years, and I look forward to many more. I want to encourage students in the audience very early on to consider public service. If you're driven by fame and, as my daughter would say, bags of money, then maybe public service isn't for you. But if, however, you're driven by passion to achieve fairness, to play a part in protecting the public, and contribute to make the world that bit safer, then maybe we should have a chat. Thank you.
Grace, thank you very much. That was marvellous. Now, Grace has very kindly agreed to take some questions. When asking your questions, if you would just give us your name to start with, and if you could make it a question rather than a statement, that would be good. Just remember, she is a prosecutor. Yes, please, Penny. Do we have a microphone? It's down here.
Thank you.
It's on.
It's on. Hello, Grace. Penny Carey, Dean of Hertfordshire Law School. Grace, how do you think a university law degree might need to adapt to equip the Crown Prosecutors of the future?
Well, I think this university has already made a start, Penny, by involving us in some of the work that you do with students. As Quinton mentioned, tomorrow we'll be having event with some of your students. I think it's about making sure that we provide information. What I get from many students that I engage with is that they don't even know that the CPS is an option. And as I said, we're the largest employers of criminal lawyers in the country. So firstly, to make sure that right alongside when they're making some of these important decisions, that they have as much information as is available, which will include the CPS. And also, as you are already doing, making sure that the activity is more practical. Because one of the, and I made a comment earlier on when I said, you know, the best lawyers are not always the best prosecutors. And what I mean by that is, you know, we can have some great lawyers who are fantastic, sort of analyzing the theory of the law. That's not me. You ask them to apply it to real practical situations and to make decisions, it's a challenge. So whether we can build in the practicality of it will be fantastic, and tell them about us. Yes.
Great. I've got two gentlemen in the fifth row here in the centre, and then gentlemen down here in the left-hand side. So this one here first, please.
Thank you very much. My name is Tony McAlister. I am not a lawyer, but your lecture was fascinating and a model of clarity for a non-lawyer. The case that you described of the man who assaulted his wife and then went on to murder her was an interesting one. And of course, if he hadn't gone on to murder his wife, the original decision would have gone down on the record as the right decision. It only became the wrong decision when he went on to murder his wife. So it was a wrong decision in retrospect. But the trouble is you can't predict behaviour.
No.
And I assume this man is now in prison.
He is, certainly.
And at some point, the decision will have to be taken whether he can be released or not.
Yes.
And once again, you won't be able to predict the future. And
No.
the parole board might get it wrong. You cannot predict the future, unfortunately, and these cases, unfortunately, will happen.
You're absolutely right, sir, and that's what makes our job an incredibly difficult one. We can't predict behaviour, but what we can do is our job, and on that occasion we didn't. I understand, and particularly in that case, that even if we had prosecuted, even if we had done all the right things, it wouldn't bring their loved one back. But it might have given them a little bit of comfort that everyone who was supposed to do what they were supposed to do did it. And that's why I found it difficult. Yeah.
Richard.
Richard Waldup, 37 years on the Harringay bench, adult chair,
So,
juvenile, and then youth court chair, and also city bench. Have you any current statistics as to the number of cases being lost by being time barred, and the number of cases where your people have to apply for adjournments because they're not ready to present the case?
yeah. I'm afraid I do.
Northampton particularly.
I am afraid I don't have that data, sir. No.
So I've got about 5. Could you all put your hands up again? I've got one up there, and I'm going to stop after that because I've got too many. I've got 1, 2, 3, 4. So if we start up on the top left-hand side up there. Sorry, in here.
Hello, my name's Jason Bowman. I work in Children's Services. I just was interested in 2 questions, really. Number one was around gangs and CPS's role in relation to gang activity and knife crime, and also around people being released under investigation without bail conditions, and whether that makes our communities less safe.
I can answer the first question, but not the second, because obviously that would be a matter for the police as to whether or not they think it's appropriate in the circumstances to release someone in those circumstances. But as far as gang activity is concerned, that is something that we have to tackle and challenged by, in particularly, we're all around the country, but particularly in the West Midlands. I think we lose sight of the wider issues when we just focus on gangs. Some people talk about black on black gangs, but actually in the West Midlands we have lots of different gangs living and operating in a very small geographical space. I think one of the concerning elements actually are those kids that are not in gangs. A fist fight which ends up in a tragic stabbing. I think we have a real challenge with our young people. And it's not just, as far as the CPS is concerned, we will charge those cases where appropriate. But it's bigger than the criminal justice system, and you would know that in your area of work. And I think it's going to involve a number of agencies working together. But it isn't just about gangs. I think it's about young people, and it's wider than that. And yes, it's a challenge.
Fascinating. Yeah, please.
In relation to domestic violence, my name's Andrew Pinder, forgive me, domestic violence prosecution, you could, in theory, factor two matters into your decision. One is the extent to which you think the complainant will give reliable evidence, and two, you could factor in what you judge to be the prospects of her attending to give evidence, because it's no secret, is it, that in many domestic violence cases, the complainants, I don't know what the percentage is, do not want to give evidence in the case. Do you take those considerations into account? If not, what is your justification?
We do, but we can't afford to do nothing, because we understand, actually, that not only do we have most of our cases that don't go ahead are victims not attending, and very often domestic violence victims. Perpetrators get to understand that that's what happens. So we look for other ways in which we can proceed with the case without the complainant attending court. And we work very closely with our police colleagues to get as much evidence. And now, of course, officers are using body-worn cameras, managed to capture a great deal, the 999 calls, the medical evidence, a lot of this. We have quite a good record of prosecuting cases where we can without the complainant attending. The other way, of course, is looking at ways in which we can get the complainant to give her or his evidence out away from the courtroom. And that's using, obviously, technology and obviously the links that we can use from other buildings other than the courtroom. And we're doing that in Staffordshire at the moment.
Lady in the middle.
Hello, I'm Layla. I'm a law student. Thank you, first of all, for a really insightful talk. There's much reporting of the general lowering of standards across the private defence practice, partly due to the near impossibility of making a living on the rates of pay and reluctance of people to join the service and stay in that area of practice resulting from that. And I was wondering what you think, that although the Crown Prosecution Service itself may be highly capable and honourable service, whether that leaves a risk of injustice over the whole criminal justice system in our country as a whole. And furthering on from that, maybe it's a naive question, I'm not sure, but what you think of the idea of having a state-run defence service to mirror the Crown Prosecution Service?
There is one. Yes, but then nobody wants to join it yet. Don't publish that. There is one.
So does it work on the same level as the Crown Prosecution Service? Or are
It's
there
supposed to. I
enhancements?
mean, it's only operating. It's quite small, actually. I can't even remember where it is now. But it's not. It's sort of a quite odd situation because it's, you know, you've got that in existence, but you've also got people sort of, you know, working privately. So I don't know where that's going to end up. Do I worry about the equality of arms? Do I worry about justice? I always do. It gives us no pleasure, actually, to go to court and not have true representation on the other side. Because whilst we have our victim in mind, we also have the public in mind. We also have the defendant in mind. That's the unique position of prosecutors. We have to think about everybody. So in those cases where we have unrepresented defendants, for example, coming to court, we have to adjust the way that we operate to accommodate that. So let's see what happens, shall we?
I've got another student, Anis, up in the tiered section there, and I'll take one more then from Rodney down the front.
Hi, ma'am. Thanks for this fascinating lecture. My name is Anis. I'm a law graduate from this university, and I'm working as president committee of the Hertfordshire Students' Union now. It was amazing to hear that you promote equality and diversity and inclusion in the whole recruitment system. And I was wondering, when you said students from all backgrounds and nationalities, we do have a lot of international students in the University of Hertfordshire, and would you encourage them to apply for CPS service and to build a career there?
Yes, I would. Yes, I would. In fact, that's not new ground for us, actually. We have some students, some people who have joined us from other countries, and we have some of them are actually working for us now full time. So yes.
Rodney.
Rodney Day, Dean of the School of Engineering and Computer Science. There are many areas of, emerging areas of technology and science. I could name a few: artificial intelligence, autonomous vehicles, yes, complex computer crimes, yes, now. And I'm wondering what steps the CPS is taking to make sure that you have a cadre of staff that, yeah, can make accurate and informed sort of prosecution and charging decisions.
Yeah, that's a really important question, because actually we're having to do that all the time. As something new emerges, we're having to train and gain a level of expertise, and we often have champions or individuals who actually we train, and we have, depending on what's going on, the team that would make the charging decisions. So yes, computer crime is one thing, but there are other emerging crimes, and we always have to be on our toes and train our people and make sure they gain the expertise to make those important decisions. And sometimes we get the experts in. It's not, for us, it's about making the right decisions, and we're not going to pretend we know stuff when we don't. So we'll get the expert in and get the expert's opinion about where we are. So that's where we are.
I'll take one more. On you go.
Thank you. Caroline Roseland, following on from that question, at the beginning of your talk, you gave the two qualifications for deciding whether to take a prosecution forward. And the first one was whether there was enough evidence.
Yes.
Now, when in the press, we very often have a different form of words. We read that a case has been dropped because there's no realistic chance of success.
Yes.
So with the increasing complexity of some crimes, like cybercrime and some frauds, do you ever take into account that a case may be too complex for a jury ever to convict?
No, we never take that view. It's our job to make that case understandable. And if we have to get experts in to help us do that, then we do. Of course, on the side of the judiciary, in some of the really, really, really complex cases, a judge might sit alone and not have a jury. So we're not precluded due to the complexity of anything. We've just got to make sure we understand and be able to present the case in a cohesive way.
Grace, that was fabulous. I am about to call upon one of our students to come and give a vote of thanks, but before I do so, will you allow me to make you a small presentation? Would you all also allow me to call Joanna Staughton up onto the stage, because I have a bouquet of flowers for her as well. Joanna. I should say Joanna has been a long-term supporter of the universities in many, many roles, and it's a real pleasure to give her these flowers. And now we have, Joanna and her family have sponsored a scholar at the university, and it is the scholar that they've sponsored who's going to give the vote of thanks. Can I invite Harry McCourt up onto the stage to give the vote of thanks? Thank you.
Thank you, Vice-Chancellor. Hello, everyone. I would like to start by thanking you all for coming out to this lecture tonight, and furthermore, thanking Lady Staughton herself for her, as Quintin said, long-standing and vital support for the law school. And I'm sure it means a lot to all the students who've been sponsored by the scholarship and also the faculty themselves. And finally, I would like to thank Grace herself for the lecture. As I'm aware, many people did say how insightful it was. And just personally, I would like to say it was an extremely insightful lecture. And there are many students here tonight, and I'm sure a few of them would now be thinking of perhaps changing their idea of a career to the Crown Prosecution Service. And I think something all of us could take away from this lecture was, I think we are guilty sometimes of a bias towards prosecutors. And following your compassion, your devotion to justice, to society, to minorities, I think that has gone away to dispelling some of the rumours and biases we have towards prosecutors. And I would like to thank you for that, and I think all of us will take that away with us tonight. Finally, I would like to say to everyone, there are refreshments outside, and I hope you would all join us. Thank you.